Article 191 of the Indian Constitution deals with the disqualification of a member of a state legislature, legislative assembly or legislative council in India. It outlines the various conditions under which a person can be disqualified from being a member of a state legislature. This article is similar to Article 102 of the Indian Constitution, which pertains to the disqualification of members of the Lok Sabha, the lower house of the Parliament of India. Here are the key provisions of Article 191. Disqualifications. Article 191 lists several grounds on which a member of a state legislature can be disqualified. These include holding an office of profit under the government, being of unsound mind, being an undischarged insolvent, not being a citizen of India or being disqualified under any law made by the state legislature. Office of profit. The most common ground for disqualification under Article 191 is holding an office of profit under the government. However, not all offices under the government are considered disqualifying. The specific offices that lead to disqualification may be defined by the relevant state legislature or the parliament, depending on whether it's a state or central office. Decision on disqualification. The decision on disqualification is typically made by the governor of the state. If any question arises regarding the disqualification of a member, the governor refers the matter to the President of India, who in turn refers it to the Election Commission of India for their opinion. The Election Commission's decision is usually binding. Judicial review. The decisions related to disqualification under Article 191 are subject to judicial review. A disqualified member can approach the judiciary, such as the High Court or the Supreme Court, to challenge the decision. Exemption and exceptions. Article 191 provides for certain exemptions and exceptions, allowing some offices to be exempt from disqualification or specifying that certain categories of members are not disqualified. These may vary depending on state-specific laws. The primary objective of Article 191 is to ensure that members of the state legislature do not hold offices or engage in activities that may compromise their independence, impartiality, or accountability in their legislative roles. This provision is intended to uphold the principles of separation of powers and prevent conflicts of interest among elected representatives.
The Constitution of India. Part 6. The States. Chapter 3. The State Legislature. Disqualifications of Members. Article 191. Disqualifications for membership. 1. A person shall be disqualified for being chosen as, and for being, a member of the Legislative Assembly or Legislative Council of a state. A. If he holds any office of profit under the Government of India, or the government of any state specified in the first schedule, other than an office declared by the legislature of the state by law not to disqualify its holder. B. If he is of unsound mind and stands so declared by a competent court. C. If he is an undischarged insolvent. D. If he is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgment of allegiance or adherence to a foreign state. E. If he is so disqualified by or under any law made by Parliament. Explanation. For the purposes of this clause, a person shall not be deemed to hold an office of profit under the Government of India, or the government of any state specified in the first schedule by reason only that he is a minister either for the Union or for such state. 2. A person shall be disqualified for being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule.